afternoon. The Senate Rules Committee will come to order. Please call the roll.
Senators Alquist? Here. Alquist here. DeLeon? Here. DeLeon here. Fuller? Here. Fuller here. Harmon? Here. Harmon here. Steinberg?
Here.
Steinberg here.
Thank you, members and members of the public. Today, of course, as you know, the Senate is in session and on the floor, and so we are meeting at a different time, but we have an important hearing today because we have two gubernatorial appointees appearing today for the Board of Parole hearings. And I would like to welcome Robert G. Doyle, Ph.D., and Jeffrey J. Ferguson to both come up to the front here. Ask you to take a seat and make yourselves comfortable. Welcome to you. It is the tradition in the Rules Committee to give the nominees an opportunity to introduce members of their family or special guests. And then I'd ask you to give a very brief opening statement about your qualifications and about your approach to the job. And then I know I have questions, and I'm sure the other members will have questions as well. And we'll proceed expeditiously here. Whoever wants to go first, welcome.
Very good. Thank you, Mr. Chairman, Senators. I'm getting there. I'm Robert G. Doyle, and I don't have any family here this afternoon or anyone to introduce. I've served for 36 years. I've served the people of California and Riverside County and also the state as a peace officer, as an administrator, twice elected sheriff, and now as a commissioner the last almost 4 years. And I love the job. It's a very rewarding job, and with your support today, I hope to continue in that work. Thank you.
Very good. Thank you, sir.
Jeffrey Ferguson, and I didn't bring any family with me here today. A little bit about myself. I will be brief. I am from Oakland. I am a retired Oakland police officer. I spent a lot of time in homicide. I conducted many interviews. I learned to make rational decisions based on evidence. Toward the end of my career, I was asked to head up the police and corrections team for the city of Oakland. As part of the police and corrections team, it was our responsibility to assist parolees in assimilating back to society. I firmly believe that life prisoners and life criminals can rehabilitate themselves. Thank you.
Thank you. And just to remind everyone that the Board of Parole Hearings conducts hearings to determine parole suitability for those who have been sentenced to life with the possibility of parole. That's the job description for members of the Board of Parole Hearings. Maybe I'll begin, if that's all right, today, and then we'll go around the horn here. I want to ask you about your respective approaches to medical parole. This issue has been in the news lately, and of course, last year, as part of the 2010-11 budget, we passed a law that would authorize the board to grant medical parole. And so you had this individual, Stephen Martinez, who was considered last week, and without any dispute, he committed a horrible crime in 1998, kidnapping and rape, and sentenced to 157 years. And while in prison, he was beaten and left as a quadriplegic. The description, of course, is that he cannot eat, bathe himself, or move his arms or legs. And he is costing the prison system, his incarceration is costing the prison system $600,000 a year. When he spends time in a medical facility, it's $800,000 a year because of round-the-clock guards. Now, I'm not saying that these issues or the kind of issues presented in this case are easy by any means, given the nature of the crime. But I'd like to understand your approach to the medical parole issue and whether or not the primary focus is the gravity of the particular crime versus whether the inmate has any physical ability to ever harm anyone again, and obviously the cost to the system, how you weigh those things.
Sir, the fundamental concern is public safety. When a inmate has been determined to be a permanently medically incapacitated and needs 24-hour care, they are determined through the medical professionals that that's the case. They are referred to us, and we conduct a two-panel hearing to determine if they are a danger to society. And in many cases, say for example, if a person is in a coma and can't move and can't commit their crime again, or can't commit a similar crime, in those types of cases, they would be often, usually, or certainly, that would be an easy one. That would be a time for them to be released. However, if a person still does have control over certain things, say they still have their mind, they can still influence people, they can still control people, perhaps they can still sexually harass, they can order a hit on someone, they might be able to manipulate people, then perhaps they could still be a danger in certain circumstances.
All right. I think that's a fair answer.
Senator Steinberg, first of all, in my opinion, it's a good idea. I mean, I'm glad to see that we've got medical parole. There is a lot of money that can be saved for the taxpayers. And, you know, the criteria is set by the physician. And so, really, as Commissioner Ferguson said, our only concern is it reasonable? Is it going to be a reasonable risk to let this individual be put on medical parole? And that's really our only concern. And neither of us sat on the panel for Mr. Martinez. But I think you're going to find there's about 49 that meet the criteria currently for medical parole. And I think we've
49 inmates.
49 inmates. And we have 10 that are scheduled for hearings in the next month or so. And I think you'll find that, you know, most of them, in most cases, it's going to be pretty clear-cut examples that Commissioner Ferguson, you know, you got individuals who, and they're comatose, and they're not harmed to anybody. But there may be some unique cases where a person has the ability and has currently made threats to medical staff or threatened that they're going to get somebody to kill them, and those types of things. And so when you have those situations, you know, you have to weigh that. But I think you'll see in most of these cases, as the medical parole gets up and going, that most of these people will get put on that, or under that criteria, will get put on medical parole.
Thank you very much. Senator Alquist.
Thank you. I had this very discussion the other day, and I thought it was a fair response to the way you talked about the issue. Before I go into my two questions, and I think you're both very qualified, I just want to make note of one thing, and that is that with a board of 15 possible commissioners, only one is a woman. And I'm sure there are some other really qualified women out there. And so I just put that into the universe for the future. Now for the questions, given the Supreme Court decision last week that California's prisons were so overcrowded that they are in violation of the Eighth Amendment, cruel and unusual punishment, the court has ordered California to reduce its prison population by 33 to 38,000. And I would ask this question of both of you as a member of the Board of Parole: how does the Supreme Court decision impact your job?
Well, Senator, it really doesn't. We're pretty focused on the lifer population as Senator Steinberg had said, that have the possibility of parole. So that Supreme Court decision, it really isn't going to impact what we do in our role as lifer commissioners.
Right. So the degree of problems that you're dealing with would be at a very different level than what we're looking at with the 33,000
That's
or
correct.
so.
Right.
Okay. When we met the other day, in addition to spending a lot of time on the medical parole, we also spent quite a bit of time on the recidivism rate. And so in regard to that issue, why do lifers have such a low recidivism rate, and what lessons can we learn from lifers that can be applied throughout the prison system? Seems rather simplistic, but I think it's an important issue.
I can answer that. I firmly believe that it's because lifers have to appear before a board. They have to appear before a panel. They have to qualify by showing that they're no longer a current unreasonable risk of danger. So by doing so, they have to behave themselves for a period of time in such a fashion that would make them suitable for parole. They need to program. They need to have a good work history, perhaps earn a vocation or at least get a marketable skill. So by doing that, they're already conducting themselves like citizens in the population that are not committing crimes. So that by doing that, they've already started being productive citizens again.
Thank you, Mr. Ferguson. And Mr. Doyle?
Well, as Commissioner Ferguson was saying, the lifer individuals that have the possibility of parole are indeterminate sentenced inmates, and they are the only ones that come before a panel, and they have to, have done certain things in order to get a grant. And the rest of the entire inmate population doesn't have to meet that requirement. They're determinate sentenced inmates. Also, as Commissioner Ferguson said, there's a significant amount of programming. Understand, by the time a lifer inmate comes to us, he or she's probably got anywhere from 15 to 20 years already in the system. If they're in on a murder, first or second degree. So they've had a lot of time to program, and also they've gotten older. And research shows that as certainly the male population gets older, their recidivism rate goes down. They're becoming more mature. Their decision making, in relationship to their environment is getting better as they get older. Plus, their programming that they're doing is assisting them. So. And you don't have that with, as you and I had spoke. We have inmates from 1 to 10 years that really we need to create a model, and we can probably take from the lifer individuals, but we need to create a model to where there's incentives for those individuals to get a GED, to learn some skill sets that will assist them back out in society. Instead of where they're just going back out, at most maybe they've become a more educated criminal, and we haven't, given them all the skill sets that they need to be successful back out in the free community, because they're not. They know when they come in, you do 7 years for a robbery, your parole date's going to be in 3.5 years. It's set. They know when they're getting out, and they don't have to go prove to anybody or show anybody that they have developed and that they have, that they're significantly ready to go out and be a productive citizen. So I think, that's why you see such a difference in the recidivism rates, for lifer inmates versus, other inmates.
So very, very last question. I know we're short on time. Given the constraints we deal with in the population and determinate sentencing, just a sentence or two, really, is there anything that you all could be doing differently to kind of change this, which in a sense would also help to lower the recidivism rate?
Well, it's just an idea, and we talked about this yesterday, that perhaps offering those prisoners, when they get released on parole, offer them incentives for pro-social behavior, such as maintaining a job or self-help on the outside.
Thank you. Did you
Yes,
have a thought on that too?
We talked about that yesterday, which I think we need to look at some new ways to create some incentives for these folks.
Good. I hope we'll be thinking about that. Thank you. Thank you.
Very good. Thank you, Senator. Senator Fuller?
Just quickly, because I'm quite impressed with your service and your merits, levels of merit awards and valor. Both of you have done more than exemplary things in other areas of your life. But briefly, just what one aspect of training or education or experience has helped you most or will help you most on this parole board to be successful in the best interest of Californians?
Senator Fuller, what I found, certainly my law enforcement background has assisted me significantly. And I've had the opportunity to deal with people from all walks of life in my career, not just criminals. And just by inherently the kind of work that we've been involved in all our lives, our adult lives, it gives us the opportunity to be able to read people. We've all had to interview people extensively, and so those life experiences that we've gone through as peace officers really assist us when we're trying to evaluate the individual across from us, and so I have found that to be very helpful in that process.
I found the training to be incredible. I've been involved in training, basically training police officers in the academy and in-service training for decades. And when I came here, I thought I knew a lot about training, but the training was intense. It was incredible. The part that I found the most helpful was I was given 3 weeks of training one-on-one with other commissioners, where I sat in as a panel member while in training. I sat in for a week with Chairman Doyle, and I learned from the other commissioners that there are excellent ways of doing things that are not exactly the same, and I picked up something from all of them, and I found that to be very rewarding.
Senator Harmon?
Thank you, Mr. Chair. I want to follow up just a little bit with the previous question because this job that the two of you are doing is a burdensome, oftentimes lonely, and far reaches of the state, remote areas. Although Mr. Doyle has been a commissioner for 4 years plus, I believe, Mr. Ferguson, you're a little bit newer, or do I have them reversed?
No,
that's
correct.
They are.
I have more gray
But
hairs.
my question is this: what can we do? And I'm told that the turnover is somewhat high with the commissioners. And so, my question is, what can be done to try and improve the retention of qualified persons like yourself and keep individuals on the commission serving a little bit longer than what I'm told the average time is only about 18 months. Any thoughts, ideas, suggestions? And also, if you just touch on the use of computers or laptop computers for information when you're preparing a file, are you using that? Is that commonly used, or are we still chasing paper?
Senator Harmon, I'm happy to report that commissioners are staying longer these days. Certainly, back when we had a significant backlog of 3,000 cases, it was pretty brutal, and the hours were fairly long. But we've got the backlog down to, I think last month it was 29 cases. So it's given us an opportunity to where we have where before we had to prep our cases on the weekend. because that was the only time we had. Now, if we, have a Friday, then we're able to prep our cases on Friday and spend additional time with our family, like, most people would do on the weekends. So from that standpoint, we've seen the retention of commissioners, the length of time grow. But, it's I think the last study, it was 66.6 hours was a normal week for a commissioner. So you've got to find people that are dedicated to serving, I think. And a lot of people, sometimes step into this job and they're not ready. I mean, they think they can do the job, and they get in and they're overwhelmed by some of the things that you just mentioned. But it is getting better, and it has gotten better.
Okay, thank you very much.
Senator De Leon.
Thank you, Mr. Chair. What is the current recidivism rate of that subset universe of the lifers?
Well, I believe it's roughly around 5%.
5% recidivism rate.
I've heard lower from inmates' attorneys. However, I've also heard 5%.
Okay, that's extremely low.
That is very low.
In comparison to the general population, which I believe in the aggregate, more or less ballpark figures around, 60, 65, 70%. Right? So when a lifer comes in front of you, what does a lifer look like with regards to you're concluding this guy has got his act together, and I think we're going to let this guy go out? What's that look like to you in front of you?
Senator, I can say that every grant that I've made, I felt confident that that person was not going to reoffend, that they have changed their life around. We will have talked to the inmate at a hearing for 2 to 3 hours about a wide variety of subjects. Many of them are very difficult topics to discuss, yet we still delve into those. We talk about their life. We get a sense of how they're thinking, and they're not thinking like criminals anymore. They have insight into the causative factors of what led to their antisocial behaviors, including their past substance abuse and their past criminality and their life crime for that matter, and they've taken steps to address each and every one of those issues, and it just comes out. You can once you've done this for a little while, and I haven't been doing it very long, but you can tell when an inmate gets it and has changed.
So it's an intuitive feel too, then, what you're saying. They can often. Well, I'm not saying you got a check off list and you got a matrix.
There isn't, because it's different. It's different for everyone. But you can tell, and oftentimes they can point to a specific thing in their life or a specific event that changed them. And when you ask the inmate, they said, what caused this change? It's always something different, but they can usually point to the specific event in their life.
Okay, thank you, Mr. President. Mr. Doyle, if you want to add anything to that.
No, just to add on to Commissioner Ferguson, is you can genuinely tell when someone has changed in their heart, and they are making the effort they've made the effort to change their behavior, and they understand why they were a violent person. They understand how substance use controlled their life, and they're able to articulate that. And also they can talk about their criminality, and also the understanding if they're gang members. They've sought out programming, and they understand the significance that their gang relationship had as it related to who they were, and they can it becomes those that change. It becomes very evident during the hearing that they have made that commitment in their heart, and that they're no longer an unreasonable risk of dangerousness to a free community.
To sort of reach this level of complete understanding, whether it was trauma, whether it was substance abuse, sociopathic behavior, the lack of empathy, manipulation, everything, and then some that gets individuals into the prison system. What is it inside the system itself with regards to, say, for example, non-traditional programming that's being offered that give us some insight, if you will, that gets that individual to that level where they have a thorough and comprehensive understanding as to why I committed this crime, whether it's low self-esteem, sociopathic behavior, manipulation, disassociation, everything and then some, if you will. I inflicted bodily injury, harm on another person because whether it's self-hatred, whether it's low self-esteem, whatever it is, because in some sense, you guys, as being not criminals, as being working with criminals, obviously, being in law enforcement, Oakland Police Department and Riverside Sheriff's Department, Riverside Sheriff's Department, you guys are sort of quasi-pseudo, if you will, therapists as well, too, and psychologists, because you're figuring out, if you will, who games the system and who actually has a thorough understanding, not a superficial understanding of saying the right things at the right time, but has a very complete understanding as to why he committed it and why he wants a second chance of life. So inside the system, with regards to all the budget cutbacks and the non-traditional programming components that are very critical for rehabilitation, and that being challenged, if you will, with regards to the cutbacks, give us some insight, if you will, and I'll finish it off there, as to how that person arrives at this cathartic moment, or whatever, however you want to call it, as to, I want to improve my life now from this point forward.
What you find is that it's kind of the old saying, it's like once they realize that they don't have all the answers, then they start asking the right questions of themselves. Okay, and like the commissioner said, sometimes it's a significant event in their life. For instance, inmate may get put in isolation and in ADSEG, and while he's in there by himself, he decides, I can't keep living like this. I've got an opportunity to get out, and I've got to start changing my life around. Sometimes it's a mother who passes away, and it has a significant impact on them. When a family member is lost, or they can't see their kids except on visiting. So it's a variety of issues that'll get them started. And with today's economy, I know personally, I don't care what kind of programming they do. It doesn't have to be official CDCR programming. I've given guys grants that have taken substance abuse programming through correspondence courses. The important thing is, whatever the programming is, you're able, when you're on that one-on-one with them, they're able to articulate to you what they've learned, and that they have set a foundation in their life, and that foundation is going to transfer to the free community for them. And in that discussion with them, you'll learn that. So just because a individual has a stack of certificates, let's say from sanctioned CDCR programs, which I'm not saying they're not good, I'm just saying that's not the only way that they can program. I mean, you start talking to that individual, and if he or she can't articulate any learning in those programs, whether it be anger management, substance abuse, whatever it may be, then they were drinking coffee and eating donuts basically while they're attending these classes. So it's really not about what programming they attend, but what they've learned from that programming, or even book reports. There's been it's interesting, and some of these inmates have some very good writing skills, and to read their book reports, and you can get a sense from books that they've read, how it's changed their life, and what they're doing to implement what they've learned in those readings into their daily life while they're in prison. So, and once they make that decision to change, they're gonna find the things that they need. It's just almost like when you're real thirsty. That's how they'll go. They'll get books from the library. They'll do the things that they have to do to learn the things that they need to learn. And sometimes it's other lifers that help them out that may change their life. Other lifers who have turned their life around in prison that will take them under their wing and help them and tell them, this is no good. You're going down the wrong road. And they'll guide them. We see that.
Senator, if I can just add, I will often tell an inmate, I use this all the time, there are many paths to suitability. Some of them are non-traditional programming. book reports are big. Sometimes it's individual to that person. Oftentimes it's through religion. I had one case, just very quickly, where the inmate, his victim was a Vietnam veteran, and the Vietnam veteran was of a certain age where the inmate was able to find another Vietnam veteran of approximately that same age, and through a series of interviews with that inmate, he developed remorse and insight that he was able to capture through a series of reports that he wrote, and he submitted those upon the time at his parole hearing, and it was obvious that he got it. He would never be a risk of committing this kind of crime again.
Okay. Thank you very much. Thank you very much.
Thank you very much for thoughtful discussion. Let's hear from witnesses in support of the nominee. Don't all come up at once. Witnesses in opposition. A couple witnesses one witness in opposition. Are there other witnesses in opposition? Not? We'll hear from the one witness. Thank you very much and welcome.
Thank you.
Please say your name and for the record.
Thank you, Mr. Chairman, Senators. My name is Vanessa Nelson. I represent Life Support Alliance. We are an advocacy group working for the increasing grants of parole to suitable term to life prisoners. Mr. Harmon or Mr. DeLeon, I can't remember which one of you asked about recidivism rates. The generally accepted recidivism rate for lifers is between 1% and 3%. Those are usually for technical violations, not for new crimes. We have a couple of positions here. We're taking actually no firm position on Mr. Doyle, and we're opposing Mr. Ferguson today. Those positions were arrived at not as the result of a knee-jerk reaction, but the last several months we have spent reviewing several hundred transcripts of parole hearings and court cases reversing hearing decisions by not only these gentlemen but others that will come before you. I must tell you that listening to the discussions today from Mr. Ferguson and Mr. Doyle, it's hard for me to recognize these two gentlemen from the things that I see in the parole transcripts when they're dealing with prisoners and the decisions that have been made. We do have a couple of questions that we would like to ask through the committee of the gentlemen here and see what we can glean from their responses. One of them is, given the recent Fourth Circuit Court of Appeals decision in re Vix regarding ex post facto applications of Marsy's law to lifers, are these gentlemen comfortable with continuing to impose 7, 10, and 15-year denials on lifers?
Well, look, I want to understand the question. How many of these questions do you have?
About 4.
Okay, it's a little unorthodox, not inappropriate for the witness to pose questions. Well, why don't we get all of them out?
All right,
okay?
We can certainly do that.
And then we'll ask the gentleman to respond.
That's fine. We have done considerable study on the Forensic Assessment Division, which, for those of senators that aren't aware of that, is a group of psychologists responsible only to the Board of Parole hearings who do nothing but lifer evaluations, psychological evaluations. This group has twice been found to be an underground regulation. And as far as we can ascertain at present, it is still in operation, and the Board of Parole hearings continues or intends to continue.
So your question is why they feel justified in using the forensic assessment?
It is indeed.
Number 3.
We'd like to know if the gentleman would be considering of allowing supporters or friends and family of inmates to attend life hearings in a non-participatory observer-only capacity, which is allowed for in the law, but to our extensive research has never been allowed.
It's discretionary, so I think it's appropriate to ask the gentleman's view on that subject. Go ahead.
And I have several questions, but I'm narrowing it down. And I think we'll leave it at that. I
Okay,
think
very good. Can you go to the first one again? The Marsy's law.
Yes, there was a
recent
recent court decision by the Fourth Circuit Court of Appeals that found that the imposition of 7, 10, and 15-year denials of parole consideration to those people who were sentenced prior to 2008 is an ex post facto application of law. And we'd like to know if the commissioners are comfortable continuing to impose those denials.
All right.
If I could,
Senator Harman, of course.
well, the last question is deals with a case from the Fourth Circuit. As you know, we're the Ninth Circuit here in the western part of the United States. I don't know that these witnesses have any information or knowledge on it. It's out of the territory, and I don't know how recent it is, so it seems possibly...
It may be, rather than have you respond to a specific case, the witness is talking about concern about the application of the ex post facto law to Marcy's Law parole hearings. And if you can just comment generally on your view on that, if you're familiar with the case, you can speak to that. Very briefly here, let's go through all three. Marcy's, forensic assessment, whether you believe that it's an underground regulation or not, and the issue of public access, or specifically supporters and family or friends of the inmates attending these hearings.
On the first question, Senator Steinberg, we are familiar with the recent, it's very recent, 4th District. It had to do with an individual. It was an individual case, Mr. Bix. And, I would like to say, we have an outstanding legal team that advises us. And that decision, the Bix case, that decision was made. Certainly, it's not over. I'm sure that the Attorney General will appeal. And, it'll go through the process. And whatever the decision is, on a larger scale, it will be, and we will follow the law as we always do.
But what's the law now, as far as you're concerned?
Well, right now, and our legal representatives have told us to continue to operate under Marcy's Law. There are some other Marcy's Law cases that are in the system that have not yet been decided, and whichever way they go, we'll conform to whatever that law is.
So you're not following this Fourth Circuit case at this point unless and until it becomes binding on the Ninth Circuit or otherwise final?
That's correct.
Okay, very good. Second question, forensic assessment, underground economy.
Ms. Nelson's talking about the psychological evaluations, and it is our understanding, again, from our legal briefing, from our legal team, the Office of Administrative Law had some procedural issues with the psychological evaluation and putting it into policy, and have asked them, and our legal team is working with them to change the procedures, some of the procedures that were mentioned in there. The Office of Administrative Law does not have the power to say cease and desist on using the psychological evaluation.
Now that I think about this, excuse me, sir, I'm not sure that it's an appropriate question to raise, but I'm not sure it's appropriate for these gentlemen. If they are relying upon legal advice from either the Attorney General or Counsel, I think what we want to do is ask Ms. Sabelhouse or someone else if they can help us report back to the committee here on the status of any regulations around the issue of psychological testing and forensic assessment. They use it, whether they should be or not, based upon whether or not using it is considered underground regulation is probably beyond your purview.
Most definitely.
So let's get an answer back from other authorities here and see if we can find the answer.
You want me to answer the third question?
Third question: supporters and friends of inmates.
My personal opinion is I don't care who comes to my hearings. Okay. The only thing that I could see that could be problematic is when you have family and friends. What's important as a commissioner is that one-on-one interaction that you have with the individual. You're trying to make a decision whether this person is an unreasonable risk of dangerousness to a free community, and you need their full attention. And with family members in the room, certainly it could be distracting for the individual who is trying to get paroled. That would be my only thought on that. But I don't have a problem. I wouldn't have a problem with it.
Okay, let's go now to Mr. Ferguson on questions 1 and 3. Do you follow that Fourth Circuit decision, or are you waiting until it becomes final or there's some additional clarity in the law?
We're waiting for additional clarity in the law.
Very good. Question 3. what's your policy or view on supporters and friends of inmates attending these hearings?
My policy is anyone that's been cleared through BPH and the institution, regardless of who they are, to attend a hearing, I am glad to let them attend the hearing. I have had supporters of inmates attend hearings. They are also victims next of kin. These are usually involving family violence cases.
Sure.
And they were supportive of the inmate, and they were certainly accommodated. They were allowed to attend. They were even allowed to speak under Marsy's law, and there were no problems.
Okay. Thank you very much for your testimony. We appreciate it. I will note for the record that at least what I have before me, the witness who I think did a fine job posed Mr. Ferguson, supported Mr. Doyle. Mr. Ferguson's parole grant percentage is actually slightly higher than Mr. Doyle's. So on this issue, I'm prepared to support both of your confirmations. I thought that you answered the questions very well, and I'm persuaded as well by some of the background work done by our staff around how they perceived your handling of the hearings themselves and the testimony, not the public testimony, but the background investigation, that you handle these hearings in a fair way. And I think that's what we ask for up here. These are cases that are heavily fact-dependent, and there is law that applies. And we want to know that despite your law enforcement background or whatever your own personal ideology may be, that you're just going to follow the law and appreciate the nuances that different fact patterns bring. And you are willing to grant parole in the appropriate cases, as evidenced by 39 for you, Mr. Doyle, and 21 for you, Mr. Ferguson, between January 2010 and April 2011. I'm prepared to support the nominations. Can I get a motion?
Move approval of both.
Thank you. Moved by Senator Alquist. Please call the roll.
Senators Alquist.
Aye.
Alquist, aye. DeLeon.
Aye.
DeLeon, aye. Fuller.
Aye.
Fuller, aye. Harmon.
Aye.
Harmon, aye. Steinberg.
Aye.
Steinberg, aye.
Congratulations to you. These will proceed to the floor, and they'll be taken up relatively quickly. Okay, thank you very much. Nice job. Tough job. Tough job. What's that? Well, didn't quite get into that. All right, we got a couple of items, and I want to take file item 2. I noticed former Senator Dunn in the audience. I don't know if he was here to testify on file item 2. Maybe not, but this is without appearance. Why don't we take file items 2, 3, and 5 as a package? Moved by Senator Harmon. Please call the roll.
Senators Alquist.
Aye.
Alquist, aye. DeLeon. DeLeon, aye. Fuller.
Aye.
Fuller, aye. Harmon. Harmon, aye. Steinberg.
Aye.
Steinberg, aye.
And now we move to, drum roll please, the very controversial SCR 46 by Senator Wolk declaring July 2011 as Parks Make Life Better month. Any comments from members? Okay. We're willing to find the middle ground here if there's a problem. Parks make life...
Accommodating and trying to find middle ground.
Parks make life mediocre. Parks make life average. We're willing to find the sweet spot. It's been moved by Senator DeLeon. Call the roll, please.
Senators Alquist.
Aye.
Alquist, aye. DeLeon.
Aye.
DeLeon, aye. Fuller. Harmon. Steinberg.
3-0. It squeaked,
Steinberg, aye.
but it passed. The record reflect. All right. That is all for the. We do have executive session now.